The other major topic that I wanted to cover in class were the sources of public international law, all of which we're going to go into much more detail in future classes. This is just planting the seeds of information. So when we're thinking about where public international law comes from, usually the biggest source is international agreements, aka treaties. There are some international agreements that technically aren't treaties. We'll get into this later. They're also called conventions, accords, protocols. But really, what we're talking about here are contracts between countries, to refrain from doing something, to act in a certain way, to implement particular legislation. Treaties between two nations are called bilateral treaties, whereas treaties between three or more nations are called multilateral treaties. The reason why we make this distinction is that the availability of treaties and the strategies we use to find them are going to be different depending on whether they're bilateral or multilateral. The second major source of public international law are decisions of international courts and tribunals. These are usually courts established by treaties with all of the rules and procedures and jurisdiction and all that defined by the terms of a treaty. These are usually non-binding on anyone except for the parties involved, but their role is to interpret and apply international law, and they might have enforcement mechanisms like establishing sanctions. The major court of the UN is the International Court of Justice. You also have organizations like the WTO dispute settlement body. I also want to highlight the difference between a court and a tribunal is that tribunals are temporary. For example, the Nuremberg trials prosecuting war crimes during post-World War II would be a tribunal, whereas the International Court of Justice and these more permanent standing bodies are courts. I don't want you to worry too much about customary international law, the third major source that we're going to talk about. We're going to have a class specifically dealing with other sources of international law. Customary international law is weird. It's basically the international common law. Nations establish it through custom. For example, a big one is diplomatic immunity. Even if a country hasn't signed a diplomatic immunity treaty, they might be bound under customary international law. And customary international law is used by domestic courts. For example, the US Supreme Court has applied international customary law in the past, and also by international courts, like the International Court of Justice. There's a big trend towards codifying customary international law. For example, there are a ton of diplomatic immunity treaties at this point, but even parties that aren't bound to those treaties may still be bound by customary international law. Another example is the principle of non-refoulement, which is when the idea that you can't return a refugee to a situation that would put them in danger. Similar to customary international law are general principles of international law. The distinction here is confusing. Both the customary international law and general principles of international law are weird. It's also like a type of common law. We'll talk more about this distinction later on. You don't have to worry about it. Part of the difference here is these are more procedural. For example, res judicata, the idea you can't be tried multiple times for the same thing, or the idea of applying equity. International courts might turn to general principles of international law when the stricter requirements of finding customary international law aren't met. The last source of public international law that we're going to talk about in class is soft law. These are non-binding instruments typically issued by intergovernmental organizations. Things like general declarations. A lot of the time, this can be symbolic, but they might lay the foundation for future agreements. For example, the Stockholm Declaration on Sustainable Development and some other environmental issues that established a framework for monitoring environmental compliance. But then you have stuff that's just kind of vaguely pronouncing the views and intentions of international bodies. That's soft law. This last bit on international law in the US, we didn't get a chance to touch on in class, so don't worry about it right now. We'll talk about it later.